I'm Joryn Jenkins at Open Palm Law. We help folks divorce each other without destroying their families or their bank accounts. 90% of communication is nonverbal. As human beings, we learn to pick up on cues, gestures, and erratic behavior that tip us off to a hidden agenda. It's the same with divorce, whether it's the wife getting ready to leave her husband or the husband preparing to leave his wife. What signals, you ask? How do I know that one of them is planning to ask for a divorce when even their spouse doesn't know it yet? I listen to the questions they ask their barber, their best friend, their nail technician. Sometimes it's a more subtle inquiry at the water cooler while attending a conference or before an office meeting. Here are some indicators of a person preparing to make this major lifestyle change. Can you recommend a doctor for hair restoration? Do you know a good weight loss program? Can you refer me to a good plastic surgeon? I'm thinking about having my boobs done. I'm considering trading my Suburban in for a Porsche. This is someone who is probably planning a big change in his or her life. Someone who should be researching collaborative divorce. Be a friend. Send him or her to a collaborative divorce lawyer. I'm Joryn Jenkins at Open Palm Law. We are changing the way the world gets divorced. I'm Joryn Jenkins at Open Palm Law. We help folks divorce each other without destroying their families or their bank accounts.
Jack and Jill met in college, fell in love, and got married. Jack got a great job working long hours, but making lots of money. Jill got a job that she loved that also allowed her to spend time raising the kids. They bought a gorgeous house, great cars, opened lots of credit cards, and had 3 wonderful children. After a while, Jack and Jill fell out of love and decided to get divorced. They consulted trial lawyers to find out what their rights were. Jack's lawyer beat Jill's lawyer to the punch and petitioned the court for dissolution of their marriage. It was war from the get-go. Jack's lawyer made nasty allegations about Jill's lack of parenting skills and how she spent money faster than Jack could earn it. Jill's lawyer counter-petitioned, accusing Jack of caring more about work than his family and of spending money on his girlfriend, a co-worker at his office. Jack and Jill were well known in their community, so the news of their divorce was spread across the front page of the Metro section. Busy courts sometimes take years to complete a divorce. The process is controlled by the court's calendar, and the longer it takes, the more money it consumes. Lawyers are expensive and charge by the hour for communications, research, discovery, depositions, production requests, interrogatories, discovery hearings, temporary relief hearings, fee hearings, battles of the experts. Often a couple's savings are wiped out and their credit cards are maxed, leading to financial and emotional bankruptcy. The parties have big bills to pay at the end of every month. Sometimes other family members and friends end up paying them. Fighting it out in court is debilitating and exhausting. Fighting it out in court emphasizes blame and incites anger where it did not exist before. In a divorce war, the couple must publicly exaggerate each other's worst characteristics and flaws. Their allegations are published in the court file for all the world to see. The couple's financial affidavits are also published there. Results in court are often not related to parties' true needs. Judges don't know them or their kids or share their values, so lawyers try to figure out how to appeal to the judge's values. The judge only sees a snapshot of Jack and Jill's lives in a few short hours. Based on this, he makes a ruling that will impact Jack and Jill and their kids forever. Judges must follow rules and may not be able to order what the family truly needs, even if they want to. Not only are the children often caught in the crossfire, but so are other family members, friends, co-workers, and neighbors. Eventually, though, the big day arrives. The divorce is finally final. But final judgments reached this way are never final. Additional litigation is common because fighting it out in court teaches nothing to parents about how to get along and how to problem solve. There is another choice. Often friends or family members, like Jack's brother, Bill, see what happens in a traditional courtroom divorce and are shocked by the devastating effects on the families. When Bill and Bonnie sadly realize that their marriage is also over, they want to avoid the destruction to their family caused by traditional litigation. Although they are getting divorced, they understand that they will be forever linked through their children, and they wish to maintain an amicable relationship for their sakes. While researching their choices, they learn of the collaborative process, wherein divorcing spouses, their attorneys, a neutral team facilitator, a neutral financial professional, and sometimes other experts work as a team to help the spouses identify solutions that are most constructive for the entire family. Bill and Bonnie each schedule appointments with different collaborative attorneys. There, they both learn that collaborative professionals are specially trained in negotiating, problem-solving, and peacemaking. They work together collaboratively, along with other trained professionals, to help the spouses develop and achieve their goals. In a collaborative divorce, the spouses are in charge of the focus, decision, and pace of the process. Collaborative lawyers function as problem solvers and educators rather than as adversaries and gladiators. The facilitator is a neutral, mental health professional who referees the team and the process, manages the emotional content of the meetings, and keeps the team on track and productive. The neutral financial professional gathers information, provides impartial financial guidance, and helps create and negotiate financial options. He wrangles financial information into place and helps the clients understand the finances. He may suggest options neither Bill nor Bonnie had considered. There is safety in the process because the participants formally agree not to go to court. Their lawyers must withdraw if the clients give up on the process and choose instead to go to court. For this reason, the lawyers are truly committed to reaching a resolution with which both Bill and Bonnie can live. And Bill and Bonnie can speak freely because nothing they say will be used against them in court. Both parties pledge to be honest and to share all information. Therefore, there is no expensive discovery process. In addition, a single financial professional is less costly than battling experts. There is privacy in the collaborative process because both parties request and the judges often agree that sensitive family issues and personal financial information may be excluded from the public record. And Bill and Bonnie can agree on options that work for their family that a judge might not be able to order because Bill and Bonnie, not some elected official who doesn't know them or their kids, control the decision-making. 4 months and several meetings later, Bill and Bonnie reach an amicable agreement, and through the process they even learn how to better communicate with one another and to more effectively co-parent. Most importantly, they are able to sit side by side at their children's important events, something that probably would not have been possible had they gone forward with traditional litigation. A collaborative divorce takes less time, costs less money, allows you to make the decisions, not some judge who doesn't know you or your kids, and protects your relationships with the people you care about, your children, your friends, your neighbors, and yes, your soon-to-be ex-spouse. It is easy to see why so many people, once they understand the collaborative practice option, choose to negotiate their divorces collaboratively rather than go to war.
I'm Joryn Jenkins at Open Palm Law. We are changing the way the world gets divorced. I'm Joryn Jenkins at Open Palm Law. We help folks divorce each other without destroying their families or their bank accounts. I am a divorce lawyer, so when people ask what I do, I tell them I help folks divorce each other without destroying their families or their bank accounts, so they can have another shot at happiness. It's terrible for everyone when people stay in hate-filled relationships, not just for the spouses, but also for their children, their families, and their friends. When this is the way it is, divorce is not a problem, it's a cure. My JD means I've earned a Juris Doctorate. I am a doctor of law, of family law. But there's more than one way to perform marital surgery. Traditional courtroom divorce is war from the get-go. Trial attorneys are frontline medics who wield bloody hacksaws, often with only liquor to dull the pain. A battlefield divorce is painful and protracted, and you may never fully recover. But collaborative lawyers like me are like surgeons who work in the calm luxury of the hospital. A safe environment. We use better tools, a team of specialists, and anesthesia administered by a professional. So collaborative divorce is comparatively painless, certainly less stressful, and recovery is that much faster. Who would you rather have doing your divorce? I'm Joryn Jenkins at Open Palm Law. We are changing the way the world gets divorced. I'm Joryn Jenkins at Open Palm Law. We help folks divorce each other without destroying their families or their bank accounts. Traditional courtroom divorce is like your morning rush hour traffic jam. Driving to work takes a lot longer than it should and makes everyone unhappy. Every once in a while, someone gets road rage, pulls out a gun, and kills one of the other drivers stuck in the same traffic jam. This is what traditional courtroom divorce is like: slow, tedious, and painful. More lawyers, judges, and spouses are killed because of what happens in divorce court than in any other type of courtroom, including criminal court. Collaborative divorce is the kinder, gentler approach to dissolving the marriage relationship. It's like a limousine, picking you up and driving you down an open highway. The collaborative facilitator is like a chauffeur who ensures that nobody suffers from the unmitigated stress caused by traffic or by the traditional courtroom divorce. Along the way, the passengers learn communication skills, problem-solving techniques, and parenting partnership practices. Collaborative divorce is the next generation of divorce, putting the dissolution of marriage where it belongs, not in the courtroom, but in the meeting room. I'm Joryn Jenkins at Open Palm Law. We are changing the way the world gets divorced. I'm Joryn Jenkins at Open Palm Law. We help folks divorce each other without destroying their families or their bank accounts. When a person has a lot of pressure on him or her, it can be hard for her to make decisions on her own. During stressful times, a person tends to seek guidance from a person she trusts. In traditional divorce cases, this person looks to an outsider, say a parent or a friend, for input. Sometimes outside influences can help to mediate, but too much input from an outsider can be toxic. If an outsider finances litigation, essentially the outsider then controls the case. The outsider might sign the lawyer's retainer agreement, making him the client, and might correspond with the lawyer directly. When an outsider finances and controls the litigation, the outsider essentially substitutes himself into the proceedings. Even if the outsider was not named in the pleadings, he becomes a party to the case just by participating. Courts know when to consider the assets of family and friends when determining a party's ability to pay. Outsiders should not become so involved that they cause either side to incur extraordinary fees. If an outsider does get this involved, the court should require this third party to pay those fees. Collaborative divorce helps remove toxic outsiders from the situation by allowing the couple to work together with attorneys and a team of neutral professionals in an effort to effectively dissolve their marriage with both parties' interests and goals in mind, all while maintaining a good relationship. I'm Joryn Jenkins at Open Palm Law. We are changing the way the world gets divorced. I'm Joryn Jenkins at Open Palm Law. We help folks divorce each other without destroying their families or their bank accounts. You've been waiting for this movie. Finally, it's showing. You buy your tickets, you get there early to grab a good seat, and you pay a small fortune for popcorn and a beverage. Finally, the feature begins. Sooner or later, you realize it's just awful. You wait for it to improve, but it doesn't. Finally, you can't take it anymore. You get up, ease your way down the aisle, and push through the side door marked Emergency Exit. Your eyes adjust to the bright day outside as you take a couple of deep breaths. You swear you'll never see a movie made by that director again, and leave. It's the same with marriage. You go in with high hopes, but eventually you realize you've made a mistake. Being miserable until the credits roll is bad. So if you're unhappy, save yourself some time and heartache, and leave. There is a less sophisticated and more chaotic way to leave a theater when you've picked the wrong movie. It's to yell fire at the top of your lungs and watch the stampede begin. People are shoved and pushed and bruised. Some are trampled, seriously injured, and traumatized. It also takes longer to exit than if you had carefully maneuvered your way quietly down the aisle. You end up bruised and broken, with your clothing torn, your wallet missing, and more devastated than ever. Yelling fire in a movie is similar to what happens in a traditional courtroom divorce. Leaving the movie quietly, with as little stress, positional jockeying, and fighting as possible, is the essence of collaborative divorce. I'm Joryn Jenkins at Open Palm Law. We are changing the way the world gets divorced. I'm Joryn Jenkins at Open Palm Law. We help folks divorce each other without destroying their families or their bank accounts. You've been waiting for this movie. Finally, it's showing. You buy your tickets, you get there early to grab a good seat, and you pay a small fortune for popcorn and a beverage. Finally, the feature begins. Sooner or later, you realize it's just awful. You wait for it to improve, but it doesn't. Finally, you can't take it anymore. You get up, ease your way down the aisle, and push through the side door marked Emergency Exit. Your eyes adjust to the bright day outside as you take a couple of deep breaths. You swear you'll never see a movie made by that director again, and leave. It's the same with marriage. You go in with high hopes, but eventually you realize you've made a mistake. Being miserable until the credits roll is bad. So if you're unhappy, save yourself some time and heartache, and leave. There is a less sophisticated and more chaotic way to leave a theater when you've picked the wrong movie. It's to yell fire at the top of your lungs and watch the stampede begin. People are shoved and pushed and bruised. Some are trampled, seriously injured, and traumatized. It also takes longer to exit than if you had carefully maneuvered your way quietly down the aisle. You end up bruised and broken, with your clothing torn, your wallet missing, and more devastated than ever. Yelling fire in a movie is similar to what happens in a traditional courtroom divorce. Leaving the movie quietly, with as little stress, positional jockeying, and fighting as possible, is the essence of collaborative divorce. I'm Joryn Jenkins at Open Palm Law. We are changing the way the world gets divorced.
Nearly everyone has been adversely affected by divorce, whether it was their own or that of someone close to them. Divorce is the most stressful event that can happen in someone's lifetime, and yet, well over 50% of all marriages end in divorce. I'm Joryn Jenkins. I'm a family lawyer. I help people divorce each other without destroying their families or their finances. I have 35 years of experience in the courtroom, and during that time I've published extensively, including my book, War or Peace, Avoid the Destruction of Divorce Court. I've received an award given only in the Supreme Court of the United States. Divorce is terrifying. There are so many questions. How do I tell my spouse? What's going to happen to my kids? How much will it cost? How long will it take? I solve that problem by offering an alternative to the traditional courtroom divorce. It takes less time, costs less money. You make the decisions, not some judge who doesn't know you or your kids or share your values. And it protects your relationships with the people you love, your children, your friends, your family, and yes, your soon-to-be ex-spouse. When I was 7 years old, my parents were divorced. My mother loaded us kids into the van and moved us 3,000 miles away. I never saw my father again. I don't want that to happen to other kids. I don't want that to happen to other families. I'm Joryn Jenkins. I'm a lawyer for families. I'm known for restructuring families, not destroying them. I'm a collaborative lawyer. Divorce is complex. Although it's a legal concept, it's a given that is complicated by many emotional and financial issues. An effective collaborative team is key to reaching a mutually agreeable marital settlement agreement in spite of the complexity of the issues to be resolved. But how do you build a better collaborative team? Well, develop good relationships with other collaborative professionals in your community. This is important because it helps to identify professionals with diverse personalities and skills to consider for inclusion on your teams and to ensure that your team is as multi-talented as possible. In addition, it's natural for people to suggest other collaborative team members with whom they have good personal relationships and they're apt to work better with those to whom they feel close. So, join a local practice group, attend collaborative trainings, volunteer for practice group committees. When a new member joins your practice group, take her out to lunch, get to know her socially. Maintain these relationships by meeting with other collaborative professionals often. Next, build a team with individuals who have complementary personalities, talents, background, skills. The differing perspectives of various team members can offer divorcing spouses innovative options that might never have occurred to them otherwise. It's true that each team member brings his own professional skills to the process rather than stretching himself to be everything for the client, whether it's the psychological and emotional understanding of the facilitator, the mathematical abilities of the financial professional, or the legal and advisory knowledge of the lawyers. But each team member also brings her own unique personality into the discussion, and thereby offers new eyes through which clients can see various fresh ideas they might not otherwise have considered. Including team members who are empathetic is also important. Empathy involves the understanding of and compassion for another person's emotional state, and it guides the individual in how to interact with others. Without empathy, the members of the team don't develop trust and connection, and the team won't be as successful. A client recently explained this concept to me. My collaborative team was like my family, cocooning me and my husband in a safe place where we could feel free to say what we'd been so very afraid to say to each other before. And we could know that our family would make sure we each understood what the other was trying to say, and that it would be all right. A code of conduct that facilitates such communication should be implemented. This code is important because it ensures that everyone is working towards the common goal of reaching a settlement agreement. Part of this code is that constructive feedback should be given in a non-aggressive manner, and that such feedback should be accepted graciously. In addition, better teams hold their members accountable for reaching their stated goals. When a final agreement is reached, a better team celebrates the team's success. Hold a collaborative signing meeting at which the professionals do not charge the clients for their time, but instead simply celebrate your team's victory. Pop a bottle of champagne or have cake. Encourage the entire team to attend the final uncontested hearing. Let the judge and the rest of the courtroom know just how proud the clients and the rest of the collaborative team is of putting together a marital settlement agreement collaboratively. The key elements of building successful teams are to develop relationships with other collaborative professionals so that you can enjoy the widest choice of professionals for your teams. Build a heterogeneous team. Develop and encourage empathy among your teammates. Employ a code of conduct. And last but not least, celebrate your team's successes. I'm Joryn Jenkins. I'm a lawyer for families. I'm a collaborative lawyer. Divorce proceedings usually stir up emotion and distress. The breakdown of a marriage is almost always traumatic and full of drama. The collaborative process is a dignified, alternative approach to the dissolution of the marriage, which offers the couple a way to resolve their issues outside of the courtroom. By opening up lines of communication and sharing information, by collaboratively problem solving with a team of professionals, and by using interest-based negotiation techniques, participants work to reach a mutually acceptable settlement agreement that fashions results based on their highest and true priorities. Many couples, certainly those with children, must continue their relationship post-divorce. It benefits them to place the dissolution of their marriage relationship in a supportive and safe environment during the process in which they can communicate openly and honestly. The pledge to share information and to be transparent not only helps the clients to trust one another so that they can effectively negotiate, but it saves time and money because the clients are not required to hunt down documents and engage in traditional courtroom discovery. A team of professionals supports the participants throughout the collaborative process. These professionals include lawyers, mental health professionals, financial professionals. They can also include others, such as a child specialist, a realtor, or evaluation expert. A critical aspect of working collaboratively is the disqualification agreement. If either spouse decides to forego the collaboration and to proceed with their divorce in court, both attorneys must withdraw. This disqualification provision ensures that all of the team professionals are focused on assisting the clients to reach a settlement and to avoid court. Also, the clients are able to speak freely without worrying that their words may be used against them in court. Because the commitment not to go to court is a formal agreement rather than just a promise, it builds trust, which helps both clients get the results they want. The collaborative team helps the participants negotiate interests, not their positions. If a party insists on a specific outcome, she's taking a position rather than negotiating her interests. If the other party takes the opposite position, they deadlock. However, if the clients discuss their underlying interests, they often uncover different outcomes. They first identify a goal, and then they brainstorm multiple options to meet that goal, rather than a single option that satisfies only one position. The process addresses all three aspects of dissolution of marriage, unlike any other divorce process: the legal, the financial, and the emotional components. Collaborative practice enjoys three key elements which contribute to its success. It requires open communication and transparency between the spouses. The negotiations focus on interests, not on positions, and the results are personalized by the clients to their family's specific needs and personality. I'm Joryn Jenkins. I'm a lawyer for families. I'm a collaborative lawyer. The collaborative team consists of a variety of professionals chosen for their specific talents to fill specific team roles, who, working together, guide the clients to a mutually agreeable settlement of their conflict issues. The team usually consists of not just the client's lawyers, but also of at least one neutral mental health professional and one neutral financial professional. For the lawyer, the collaborative process is a paradigm shift. She voluntarily delivers or divulges documents and information. She will not take advantage of known mistakes, misunderstandings, errors of fact or law, miscalculations, or other inconsistencies. The collaborative lawyer will disclose such errors and seek to have them corrected as quickly as possible. The collaborative process cannot proceed without both parties being represented by a collaborative lawyer and without the disqualification provision that the lawyers withdraw if the clients decide to forego the collaborative process and take recourse in the courtroom. The lawyers voluntarily resign should this happen. In addition to the lawyers, there's usually a mental health professional involved. The MHP can play the role of a facilitator, a child specialist, or a consultant to the team. As facilitator, the MHP maximizes effective communication throughout the process by modeling and coaching participants to build and maintain effective communication skills, use active listening, and self-manage difficult emotions. As facilitator, the MHP also improves negotiations by helping participants identify, communicate, and prioritize personal interests and goals, identify and explore options for decision-making, and identify the best alternatives for potential agreement. As a child specialist, the MHP encourages participants to remain focused on the needs of the children, to identify children's specific risks and concerns, to identify common parenting goals, and to prepare a parenting plan that meets the emotional and physical safety and ongoing needs of the minor children. As a consultant, the MHP provides advice with regards to competency, substance abuse treatment, out-of-state residence, or domestic violence. A financial professional is a neutral advisor, qualified also by training, education, skill, and experience, who's engaged by both of the clients to provide objective and unbiased financial advice. In collaboration, the clients pledge to be transparent. Thus, there's a full and candid exchange of information about the nature, extent, value of, and any developments affecting the client's incomes, assets, and liabilities. Because the FP is more accomplished at determining whether a client is hiding assets than most attorneys, the clients can feel comfortable that any hidden assets will be discovered. The FP's objective is to facilitate financial information gathering and problem solving between the clients and among the rest of the collaborative team. Thus, the role in the collaborative process typically includes helping parties divvy up their debt, informing parties how to maximize their incomes and assets that they have, helping parties to untangle their intermingled finances, working with the parties to budget, instructing the parties about their options for property valuation, and educating the parties on property and reimbursement claim issues. The clients save money because they retain only one FP, not two, and because the FP does work that the lawyer would otherwise do, but typically bills at a lower hourly rate than the lawyer. In addition, the FP spends no time or energy defending his opinions as well as reaching them in the first place as he would if he were in court. In the collaborative process, a team supports the clients as they reach a final settlement agreement. One of my clients described her collaborative team as like a village, in bringing their various skills to bear to enable the clients to negotiate in the transparent but confidential safety of the collaborative process, allowing them to address not just the legal issues, but also the financial and the emotional issues as well. The collaborative problem-solving process is based on interests rather than on positions. Folks involved in interest-based negotiation focus on why they want what they want in order to ensure that they've truly identified their interests, instead of miring themselves in an entrenched position simply because they find themselves during heated negotiation taking a position in opposition to the so-called opposing party. The collaborative team supports the clients as they work through a series of established steps to find solutions to their issues, to find resolutions that will satisfy their interests. The first step is to establish the ground rules. Ground rules are important because they facilitate communication throughout the entire process. Some examples of ground rules are to be polite, be patient, be honest, listen actively without interrupting, speak only for yourself, using I statements instead of you statements. The second step is to identify and prioritize your interests and concerns. Focusing on positions, not on interests, limits settlement options because the clients aren't able to see that there's more than one way to resolve issues. In the collaborative process, the professional team works to focus the participants on achieving their goals rather than on demanding their positions, so that the clients can see that there are multiple options that will accomplish the same goals. The temporary issues and concerns are addressed first because clients won't be able to effectively negotiate if they're fixated on urgent issues that they feel must be addressed now. Once interests are identified, the third step is to gather and exchange information. The clients will review financial and other important information with the appropriate neutral professional, as well as with their lawyer. This exchange of information allows the clients to be fully aware and prepared for the discussions that will take place around the conference table. The fourth step is to brainstorm possible options for solving the particular issues of the case. Brainstorming happens in a relaxed and casual atmosphere in which both parties feel that they're being heard. It happens at a relatively fast pace, so that the clients don't have time to self-evaluate or to arrive at preconceptions about options. The idea is to explore as many options as possible and not to judge any as they are suggested. The fifth and final step is to evaluate the options. The clients will determine how well their interests can be met by the proposed solutions. The team will discuss the costs and benefits of each proposal. Ultimately, the clients decide which option suits their need for each particular issue. I'm Joryn Jenkins. I'm a lawyer for families. I'm a collaborative lawyer. Divorce is never easy. It's one of the most stressful events a person will ever have to endure. However, if it's inevitable, there are several things you should avoid doing. The first mistake is to assume that you have to go to court, that you must litigate. While a final judgment signed by a judge is required, there are diverse routes that lead to that piece of paper. You can negotiate an agreement at your kitchen table. You can hire a mediator to help both of you work out the details of an agreement. You can both retain cooperative lawyers. Or you can both employ a collaborative team to help you negotiate the terms of your divorce. If you're successful at one of these forms of alternative dispute resolution, you will be required to attend a brief 5 minutes, final uncontested hearing so that the judge can enter your final judgment. But you'll avoid those heart-stopping hearings and intimidating depositions. It's your choice how you choose to get divorced. But you both have to agree on it. Otherwise, the default process is through the courtroom. The second mistake is to empty the joint accounts. This is a mistake for several reasons. The party who takes such a step will lose credibility in the judge's eyes. Second, the parties are each arguably entitled to 100% of the marital assets, so any assets that disappear may very well have to be returned. But because in most jurisdictions the assets are split 50-50, you're probably safe in taking 50% of whatever you own together and placing it in a separate account. Talking trash is the third mistake. It might feel good to vent, but you need to be wary of the consequences. Any exchange that's not just with your lawyer is not confidential, and your children can be harmed when they hear hurtful things about their other parent. If you must vent, use a journal. Write down your thoughts. Posting on social media is the fourth mistake. You might be tempted to brag about your new life so that your ex knows that you're over him. However, don't post anything that might be used against you. Details about the keg you finished by yourself or the one-night stands that you've enjoyed since you split will not help your divorce case. The fifth mistake is to file false charges. Telling cops that your spouse hit you is not the right way to announce that you want a divorce or to get him out of the house. It's a declaration of war, and your kids and bank accounts will suffer in the ensuing firestorm. Instead of filing a baseless or untruthful injunction, be brave. Talk with your spouse about a divorce at the kitchen table, or if that's uncomfortable for you, have the discussion in a public place, or ask a family member or friend to be present to facilitate your talks. The sixth mistake is to fail to obtain a second opinion. Lawyers have different personalities. You want to ensure that you retain one whom you like and who shares your values. Also, lawyers are human. They have biases. Most attorneys prefer a certain process like litigation, mediation, or collaboration. Pick one who enjoys working in the process you prefer. The seventh and last mistake is to hire a trial attorney without considering a collaborative approach. A collaborative divorce will save you time and money, prevent emotional trauma to you and to the ones you love, ensure personalized results, and protect your relationships with the people about whom you care. While most divorce processes address only the legal and financial separation between parties, CP addresses the emotional element of the dissolution of your marriage as well. Don't make these 7 mistakes when you prepare for your divorce. I'm Joryn Jenkins. I'm a lawyer for families. I'm a collaborative lawyer. Not everyone is suited for collaborative divorce. However, with knowledge of key beliefs and behaviors and a bit of preparation, the vast majority of our clients are successful. Our clients' beliefs and behaviors that determine success in the collaborative approach to dispute resolution fall into 3 categories: behaviors regarding their children, behaviors in how they communicate, and behaviors in how they perform during their collaborative meetings. First, let's consider the beliefs and behaviors of people who are likely to be successful in the collaborative process. These clients put the needs of the children first in everything they do. Their communication facilitates agreement. They express their own ideas clearly and succinctly, but they also listen actively, asking questions and listening to the answers. In addition, they are able to speak in normal tones, and they don't interrupt. They are able to empathize with their partner. They are willing to be transparent. They are able to trust the team and their spouse. Besides focusing on the children and employing good communication skills, how they perform during the meetings determines how successful they will be as well. Successful clients are receptive to suggestions and alternatives. They are able to search for solutions that help both of the participants. They are able to discuss and confer with the other client. They can stay in the room no matter what is said. They arrive prepared because they've done their homework. And finally, they have realistic expectations for what will be accomplished at any given meeting. The beliefs and behaviors of people who are unlikely to be successful in collaboration obviously contrast with those I've just described. These folks fail to put their children first, and sometimes even put the kids in the middle of their disputes. Their communication skills make coming to an agreement difficult. They accuse, they blame, they complain. They speak for the other client instead of for themselves. They withhold pertinent information. They can't engage in necessary and sometimes difficult conversations. In addition, even when they appear to listen, they fail to listen actively. People's performance during meetings can also diminish their effectiveness. Unsuccessful clients lock into positions, they arrive late or unprepared to meetings, and they fail to take care of their mental and physical health because they simply don't understand that being at the top of their games is critical for success in the collaborative process. Before engaging in the collaborative process, be prepared in order to be as successful as possible. 3 areas on which you should focus are how you perceive your children's needs, your communication skills, and your performance during the collaborative meetings. I'm Joryn Jenkins. I'm a lawyer for families. I'm a collaborative lawyer. War or Peace? Why did I write it? The book is not intended for collaborative professionals. It's intended as a resource for the layperson, the average guy or gal on the street who's considering getting divorced and who's at a loss as to how to approach his course of action. War or Peace is a book in which I hope collaborative professionals will invest, but in order to hand out to their clients. It should be a resource that they will want their clients to read prior to deciding how they want to be divorced. Divorce is a terrifying unknown, even to many lawyers if they don't specialize in family law. There are so many questions. How do I tell my spouse? What's going to happen to my kids? How much will it cost? How long will it take? This book will answer those questions, sure, but more importantly, it will explain the choices that every person contemplating divorce has, the crucial choice of process, of how to approach the legal, financial, and emotional separation from your partner without destroying your relationships with all the other people you care about, your children, your extended family, your friends, and yes, your soon-to-be ex. I have 35 years of experience in the trenches. I've seen the courtroom dramas that many families suffer through just to get that final judgment of dissolution of marriage. I've shared the stories of those families in this book, but for contrast, I've also shared the stories of what I call the courtless divorces, those that took place in the conference room or at the kitchen table, whether negotiated, mediated, or collaborated. It's these divorces that inspire me to try to ensure that everyone contemplating divorce understands the choices she can make and that she can choose a kinder, gentler divorce. I've actually had clients tell me their divorce was a positive experience, that they learned something as they worked through it, that they came out of the divorce as a better person. How often does a family lawyer hear that? I've had clients and their spouses explain to me that their collaborative team was like a family, enabling them to say things they never thought they'd be able to say to each other, and to hear their spouse when their spouse did the same. How often does a family lawyer enjoy hearing that? Only in a collaborative divorce. Read my book and you too can enjoy a good divorce. I'm Joryn Jenkins. I'm a lawyer for families. I'm a collaborative lawyer.